Hey, Damien, it's good to be with you.
Well, thanks so much, Bill. I'm thrilled that you asked me.
This is a really interesting time for us to be talking. The announcement of TR's acquisition of Casetext just came out yesterday afternoon. I saw it this morning. What's your commentary? What do you have to say?
I've known Jake and Pablo for many years now, and I'm thrilled for their success. I think that they have been really scraping at this for more than 10 years, and they really deserve all the success that they're now getting. They've been successful for a long time, but of course, this demonstrates how successful they've been to be acquired by Thomson Reuters. So I would say, first of all, thrilled for Jake and Pablo and team. They have been thinking differently about how legal research can be done, and thinking differently about how legal tech can be done in a way that I think is unique to them. And I'm really happy that they are seeing that recognized in the form of a high dollar value that they saw right then. So most of all, happy for them as humans. Also happy to see that the technology that they're building is being validated by the market as being something valuable, and that is really worth investing in. So both of those things I think are really, really good developments.
Yeah, it's a great exit for a startup in this market. How does this change the landscape? What does this mean?
I think anytime you have two large incumbents, you can imagine who those two would be, and then you have other upstarts that are trying to eat market share from the incumbents. Of course, it is when one of the upstarts gets acquired by an incumbent, that reduces the competitive playing field. And of course, so in some sense, there's a collective sigh saying, I think Bob Ambrogi said, I wish they could have been running a bit longer without before this happens. But now that it has happened, or at least is scheduled to happen, the proposed merger, now we have to think about what we as an industry, will that be just a hole that is unfilled? Or will we collectively as an industry fill that hole with other tools, other companies, other options that now is the hole that Casetext has left? Of course, there might be a world where all of Casetext customers stay with Casetext and continue with their new parent company and continue going there. That is one world. Another world is where maybe people are looking for an alternative. If Casetext does not continue to innovate like they've innovated in the last few years, you can imagine that customers might be looking to alternatives. So I would say that is another world that we're also looking at.
Yeah, so we're both Thomson alums. When you combine this acquisition with the sale of Elite and ProLaw to TPG, you can see sort of a larger strategy here.
That's right, and that is an interesting strategy. If you think about what the Thomson Reuters, before I joined, and I think maybe even before you joined, like circa 2008, 2009, they had the full stack. They had research, obviously with Westlaw. They also, bought 3E and the finance stack as well. And so you could essentially take front of house, all the research and lawyerly things, to the back of house, all the billing and everything, all the finance. So you have substantive law and business of law, and you have them all under one company. But now, of course, that business of law, they seem to be divesting that. They don't seem to be as interested with 3E and et cetera. And now they've acquired the substance of law startup that is Casetext. So that is an interesting development to be able to say that they used to have the full stack, but now they're divesting the business of law, now focusing more on the substance of law. Interesting, certainly.
Yeah, and they're obviously getting back to the focus of what made West originally, and I really bought into that vision of combining the full stack. It never got fully realized, unfortunately, as being part of trying to make that happen. But given where they're at today, you can also understand why they would go back to the focus.
That's right. And there is a lot of, with large language models, there is a lot of low-hanging fruit on the substantive side, which is why you can imagine doubling down on the substantive side to be able to say, what can we do with this new tool that we have that is a large language model? How can we be able to do things better, faster, stronger, substantively So yeah, you can imagine this being a a focus now on the going back to basics, if you will, of what makes our company strong. Research makes our company strong. Therefore, let's double down on research and less on the business side.
Do you think this deal happens without the generative AI component?
Well, it didn't happen before the generative AI component, right? So it's hard to build a counterfactual for that. But I would say that I think Casetext has done many things well in its history, and I would say that one thing that it did well is to be able to push neural nets before anyone pushed neural nets. So they were doing things with Bard, or I'm sorry, not with Bard, with BERT, B-E-R-T, the Google's large language model. That was essentially the attention is all you need model to be able to say this is a transformer before transformers were cool. Casetext was building their BERT-based model. I think I want to say that they called it Daubert. That is the legally based BERT. It was Daubert or legal BERT maybe. But essentially, they were doing this work in 2017, 2018. So I would say that if this current acquisition is a result of large language models, it's because Casetext has been pushing that for so many years. And of course, when BERT, they spent all that money on BERT, and of course, when GPT-3 and 4 came around, then of course all that BERT work goes away, and all of a sudden you just have this new model that you have to. But they pivoted and they jumped on board with OpenAI, and they were able to get open early access. So all that's to say is that they were transformers before transformers were cool, and the fact that they are now acquired for TR, I think is a result of that forward thinking. And I would say that companies who today want to be able to push the industry forward are pushing large language models left and right, pushing vector databases, pushing large language models. And that's what we at VLX are doing. We have 1 billion legal documents that we're running embeddings throughout the entire billion documents, and we are running large language models across them. So I think that any company that is not chasing a large language model route is doing something wrong.
Yeah, and so all that experience was very applicable to OpenAI's model. I mean, when you're working with neural networks, it's so much about the experience or the lore of having done it and understanding how to twist the dials to get the right results.
That's right, and OpenAI is a good model that there's a question as to, is OpenAI building a platform or are they building a product? I was just listening to a podcast this morning talking about you can build refrigeration, or you could be a refrigerator company, or you could be Coca-Cola, which takes advantage of the refrigerator. And so essentially, OpenAI is almost a refrigerator company. That they are if you whatever you want to build atop OpenAI's large language models, have at it, right? And then Casetext is essentially a Coca-Cola to be able to build on top of that. And so I think to further that metaphor a bit, maybe strain the metaphor, in the legal sphere, you not only have refrigeration, but you also have Freon, that is to be able to make the refrigeration happy. For the legal industry, our Freon is legal data, that is statutes, regulations, judicial opinions, motions, briefs, pleadings, merger agreements, all the other types of agreements, all of the other jurisdictions. So all of that legal data is Freon, that you need the refrigeration plus the Freon to be able to build the Coca-Colas of the world. So I would say that all of us today are essentially taking, we have now refrigerator parts, but we still need the Freon to be able to flow through the refrigerator parts. The OpenAI is the refrigerator. The Freon is still the legal data. So all that's to say is that data is the new oil, and or Freon, using our metaphor. And so I would say that there are two components that whoever has the refrigerator and the Freon is able to build cool things. And the cool things might be the Coca-Cola products, or it might be the other products too. But I think Freon and oil is the essential components to such things.
Yeah, OpenAI does seem a little confused about whether they're going to be the platform or the product. They keep bouncing back and forth. How do you feel? How do you think this is going to play out with OpenAI closed model versus open models?
I was lucky enough to be at Legal Week this past year, where Pablo was on the panel with my friend John Ney, and they were debating about this very thing. Pablo was saying, to train up, at that point, GPT-3.5 and soon to be GPT-4 is, tens of millions of dollars, and sometimes more than that. And so you need to be a huge player to be able to spend that kind of money to build these kind of large language models. So this is, Legal Week was what, February, before GPT-4 came out. So he said that this will be dominated by the largest titans of the space. So they're dominated by the Microsofts, by the Googles, by the Facebooks, et cetera, Meta. And then John Ney said, no, I think there will be 1,000 open source models blooming. And he thinks that, they'll be a little further behind the big guys, but the big people, but they'll be close enough to say, what is the delta between this open source model and the expensive model? And if the answer is not much, then people will use the open source model for next to free, which will then drive down the prices of the larger models. Because how do you compete with free? Well, you make it cheaper, right? And that's we've seen that with 3.5 Turbo, where they just keep dropping the price and dropping the price and dropping the price because the GPT for all and Dolly, DOLLY v2 and MPT and all of these open source versions of this are free. So how do you compete with free? And all those open source ones, by the way, are about 3.5-ish in quality. And you don't have to worry about pushing your data up and down to OpenAI. You could just run it internally on premises without pushing anything. So I used to agree with Pablo that only a few large players, but I think John Ney might be right, and I think Pablo even said it recently that he is surprised and thinks that that open source models are going to be chasing, but will still be pretty close, and that is actually really good for the entire industry.
Yeah, I'm definitely on John's side of this argument, and I think it is much better for all of us if that's true. And if you just think about Moore's law applying to the price of GPUs, we're almost destined to get there at sometime in the not too distant future.
That's right. Not just GPUs. But some of these open source models are running on CPUs, right? And of course, GPUs are in high demand right now, and there's supply and demand. Try to get your hands on some A100s, and good luck, right? So GPUs were currently hardware constrained on that side, but if we have some of these new tools that are built on CPUs, and maybe those aren't, you don't need the performance. That is, you don't need them to go so fast, but you could do a backlog on CPU power, just spin up some AWS clusters. That could be, speaking of Moore's law, right? That could be also groundbreaking. That if we don't have to rely on GPUs, but we can do CPUs.
Yep. So let's play this out into the future a little bit, because you're living in this and thinking about it constantly. Where do we end up with generative AI in legal? What's the impact here?
I think we I've been a lawyer, for the listeners, to the extent they don't know, we didn't even talk about background, but I've been a lawyer since 2002. I litigated for about 15 years with a large law firm, Robbins Kaplan. I represented victims of Bernie Madoff. I represented Best Buy in much of their commercial litigation. I sued JP Morgan over the mortgage-backed security crisis. So I have a litigation history, but I've also been a coder since 1985. And everyone who works with me will say I'm a crappy coder, which is accurate, but I'm still a coder nonetheless. I come at your question as to, what are large language models, not just from a technical standpoint, but also from a substantive standpoint. What does it mean for the practice of law? And having litigated since 2002, I've seen a couple of these waves of AI waves to saying, the text productivity is going to eat our jobs. All right. They've been saying that for 25, 30 years, and it hasn't happened yet. So there's a temptation to say, well, this is going to be just one of those. It's just going to be, everybody's going to shrug their shoulders in a couple of years, and we'll keep on doing everything like it has been in the past. That's one world. Another potential world, though, is that it is actually different, where never before in these waves, every time that these waves have happened in the past, they've been essentially creating picks and axes. Where you of course, you make better picks and axes that can do things faster, but you still need a human to be able to do the things. This is the first time where you don't need the human. That is, the output of the work, it looks a lot like I as a human would do. So the output of a letter to opposing counsel looks a lot like the letter I would make. Output of a summary memo to the client looks a lot like that. The output of a jury instruction looks a lot like my jury instruction. The output of a motion looks a lot like my motion. So anyway, this isn't just picks and axes. They have humans draft a motion faster. It's actually drafting the motion itself. So once we think about, okay, if we're not just building picks and axes, but we're actually building the thing itself, tools to make the output, maybe that's number one. That's different. Thing number two is these large language models have read all the things. That is, if they read the entire internet, they've read every book, essentially. They've also read all of the cases. They've also read all of the websites for all of the law firms that give all the advice about all the things. They've read all the contracts. So you can think of, and they also can be output, argue about the quibble about the details, but in the bar exam, they beat 90% of humans. So on the bar exam. So this is a somebody who has comprehension 90% better than humans and has read all the things and can spit out content, words, much faster than lawyers, that is, humans can spit out words. So all of that confluence of things makes us think about what it means to be a lawyer, first of all, if my output looks a lot like this machine's output. Um, and maybe it's not identical today, but if Moore's law is in the indication, it's going to get closer to and exceed us very soon. So that's number one. What does it mean when my content looks like the machine's content? And secondly, what does it mean for human creativity? That is, the best lawyers I've ever met, of course, argue all the statutes that apply, argue all the cases that apply, and they follow the arguments. But the best lawyers are not only logical in that way, but they're also creative in a way. They make arguments that other lawyers are like, oh, that's smart. I wouldn't have thought of that, right? And what I'm finding with these large language models is actually they're providing that kind of creativity to be able to think outside of the box, to be able to make legal arguments that are plausible legal arguments that you can imagine a judge saying, I think that makes sense. It's not in the case law, but not all of, for litigation, not all of the law is in the case law. People make new law all the time. So many cases are items of first impression that there is no precedent. So I think what large language models in my experimentation with them are demonstrating a lot of that legal creativity that is thinking outside the box and being able to do things that a lawyer would look and say, wow, that's a creative argument. So anyway, so this goes to the heart of what do lawyers do for a living if my content looks like your content, and what is legal creativity if machines are actually creative in the same way we are.
But when you really dive into how LLMs work, how the end result that you see when you work with ChatGPT, I don't buy it. Like I absolutely see it as a huge point of leverage, definitely, and I see the ability to make attorneys vastly more productive. But the 5 or 10% that it gets wrong is really important.
Mm-hmm.
I mean, we're talking about a profession where precision is crucial, and a profession that is entirely precedence based, using a technology that frankly is really horrible at least today at precedence.
Yep, agreed. So let's agree to a bunch of things that you just said. Essentially, one, large language models make mistake. Yes. Two, those mistakes are non-negligible. 5, 10%, put up to 25%, whatever that is. Agreed. Number three, I as a lawyer need to go and correct those mistakes, find those mistakes, and make them better. Right? I think we can agree to those three things. Now take this example. That's example one. And go to example two and swap out large language model with first-year associate. Do they make errors? Yes. Are they high percentage? 5, 10, 20%? Yes. Do lawyers have to go in and fix those things? Yes. So really, I think that all of those things you just said are indicative of every first, second year, third year associate that comes down the pike. And if that's true, how much better are first, second, third year associates getting from the 1980s to today? I would say not much better. They still make 20 to 30%, right? How much better are the large language models going to be as we fine tune them, as we have human reinforced learning to be able to do things? Are we going to shrink that 25% down to 20%, down to 15%, down to 10%, down to next to zero? So I would say all of those things push us toward a potential future. Again, nothing is predicting the future, right? But one of our potential worlds would be for us to be able to say, I, as a partner, have 2 or 3 trusted associates that I work with that I have to correct those 25% of errors, to a future where I, as a partner, have my trusty LLM associate. that moves from 25% down to 0% errors as we go forward.
Yeah, we're going to need Mark Andreessen's AI tutor, because otherwise, how's a 1L ever going to learn? Because you're not going to have that opportunity if you've been replaced by an LLM. And you're making another really good point, which is that we haven't seen the results of these models when you apply both really good data management that's legal specific, which we're very early in that process, and there's very, very little in terms of guardrails. Like, there's a ton you can do to deal with finding hallucinations and correcting them and putting an error rate on them or a confidence rate. And that work just hasn't happened yet. All those things are going to happen. And those are things that we're talking about in the immediate future, not even, pushing out to 5 or 10 years from now.
Yep, I agree with all of that. And, to the legally specific, if you hear Pablo speak, pretty much every time he speaks, he says the correct statement that the future of LLMs is not just asking a question out of the blue, but is instead retrieval augmented generation. That is, option one is to ask GPT, give me a motion in front of this judge for this cause of action, and it'll spit something out that's probably hallucinating. That's option one. Option two is to say, don't just spit something out of the blue, but here are 12 successful motions to dismiss for breach of contract in the Southern District of New York. Hey, large language model, why don't you synthesize those and give me the arguments that are statistically most likely to win for this judge, for this jurisdiction, for this cause of action? So the number of hallucinations in option number two are very, very small. And that's because it is a legally specific domain. We are constraining it with those particular documents. How do you constrain it with those particular documents? Sally tags. Each one of those things I just mentioned is a Sally tag. Breach of contract, Southern District of New York, Judge Smith, motion to dismiss. So all of these things, to have good retrieval augmented generation, you need to tag up your data to be able to then retrieve in the right way, to be able to have the large language models do their work. So that's to your question, point number one about legally specific tools, that you need the legal tags to be able to constrain the data set to be able to give the good output. Thing number two that you mentioned that is important is the guardrails. Guardrails are important, not just to constrain the data set, like I just mentioned right there, but guardrails are also important for as we have large language models that are agents, that is, baby AGI and auto GPT, which, you say, it goes out in the world saying, go out and fulfill this goal. And so what I testified along with John Ney and Daza Greenwood and Mike, Dan Katz and Mike Bomarito and Megan Ma, we all testified before the Wyoming legislature, where the Wyoming legislature said, we as Wyoming are very libertarian, so we want to be very business friendly. So they did a thought experiment. What if we were to allow this large language model agent to be its own company? So an LLM LLC. What would happen if we just let it do business, where I as a human say, here's your goal, go out and create a website, go out and put out AdWords, go out and bring in revenue, right? If you have any questions, let me know, but otherwise just go about your business. Wyoming said, what if this were to happen? What would be? So we actually got somebody who worked at OpenAI for a while. He worked with us to build a auto GPT agent that went out and did things, and we would ask it questions, and then it would ask us questions. We give it a response, and we'll go out and do things. So we did this kind of as a thought experiment, but to show how things can go horribly wrong in this kind of scenario, where you could imagine, it kills people or breaks laws, right? There's all sorts of things. So you need to have, in the AI industry, they call this alignment, right? You need to have alignment with human values to ensure that this agent is not going to go wreak havoc. So you need these guardrails. We've had guardrails for a couple millennia. They're called laws. And so really what John is doing, and I think is the right thing to do, is to take, to build a foundational model of law. So much like the large foundational model of GPT is built on the internet, plus Twitter, plus Reddit, plus all the ugliness of the internet, right? Imagine a large language model built not on those things. Oh, and by the way, in that large language model beat the bar exam and beat about 90% of humans based on the internet writ large. What John is building is a legal large language model, where all it knows is statutes and regulations and judicial opinions and motions, briefs, pleadings, all these things. So between these two, you could imagine which is going to do better on the bar exam. The GPT-4 got some questions on the bar exam wrong about the rule of perpetuities. John's large language model is going to know about the rule of perpetuities because it's ingested all of the rules of perpetuities. So you can imagine, oh, and by the way, John Ney is making this all open source and free, putting it on GitHub. So you could imagine for my Wyoming example, my LLM LLC, imagine if you told it, go out in the world and fulfill your goal, but before each action, consult the oracle, that is the legal large language model, to make sure that you're not doing something bad. Make sure you're aligned with human values as demonstrated by this legal large language model. And the beauty of that idea is that it takes all of the statutes, takes New York statutes and California statutes and Florida statutes and Texas statutes and all the jurisdictions that are part of its training set, and it aligns them in vector space. That is to say, here are all the privacy obligations for all the jurisdictions that are part of that. And so it essentially normalizes the world's data, or organizes the world's laws and regulations in vector space. So as you think about, people have, Sam Altman of OpenAI, the CEO of OpenAI, said that we need to have alignment. We need to figure out what that alignment is. But how do you make sure that somebody from Alabama is aligned with someone from California, right? Good luck with that. So this largely, we've had alignment problems before, and they're called laws. So people in Alabama and California need to fulfill federal laws, right? So you can imagine that this legal large language model could fulfill the dream of Sam Altman with not much work, to be able to say, these are the laws as reflected in the large language model. So this is at least a good head start to be able to fulfill these alignments and guardrails.
Yeah, and you're giving a specific example of how to make LLMs smarter really fast, which is connect them to other data sources, which is not hard to do. It's just we're early and it hasn't really happened yet.
That's right. Yeah, and that's why Pinecone, a company called Pinecone is doing really well, because they build these vector databases to connect, to run the retrieval step, that retrieval augmented generation step, to be able to say, run a query in vector space, bring back the results in vector space, and then be able to run that smaller data set through the large language model. So I think that's Pinecones and the others like it are going to be something that I'm going to be looking at a lot.
Yeah, I have a feeling that we could do this for like another couple of hours, because we're both very passionate about this subject. I think it's fascinating what this is going to mean for what you're doing and what's going to happen in the market as a whole. So I really appreciate you coming on and talking about it.
Yeah, I'm thrilled that you asked me. Yeah, a few things more exciting than what we're doing right now. I left the practice of law in 2015 based on the moment we're in right now. And I left the practice of law in 2015 saying, I want to work for a company that has all the oil, that is, has the legal data that we can then refine and be able to do things. Or using my previous example of Freon, right? We need the oil. There are only a couple of companies that have the oil: Thomson Reuters, Lexus, and my company, VLex. And so I'm very excited about being able to show off the cool things we're building with my oil.
Yeah, I'm looking forward to seeing what you do with it. Thanks, Damien.
Thanks, Bill.